Hello and welcome to Topic 10, Lecture 2. And in this, we're going to be continuing our discussions of the right to privacy and abortion rights. All right, so what are we going to cover in this lecture? Okay, so we're going to take a look at the response to Roe, both the social and political responses to Roe. And in that that will lead us to the next major case as it relates to abortion rights, which is the Casey case from 1992. And then we will end our lecture taking a look at abortion and the Roberts Court. In particular, as you know, that the Supreme Court heard oral arguments in the case Dobbs v. Jackson Women's Health Organization this term, and they will be deciding this case. It has to do with a Mississippi law that outlaws abortion after 15 weeks. So that's what we've got on the docket for this lecture. Let's go ahead and get started. All right, so following the Roe decision, the response to that decision was really strong and polarizing. Keep in mind, as I mentioned in the last lecture, that abortion rights really wasn't a salient issue. It wasn't what drove people to support a particular party or a particular candidate. But that all changes in the 1960s and really in the 70s after the decision in Roe. So, we talked in the last lecture about how the 1950s and 60s was this time of social upheaval, right? We have the civil rights movement, we have the anti-war movement, we have the women's rights movement, we have the LGBTQ rights movement, right? And those movements are, sort of more on the left side of things, right? More of liberal social movements. Well, in the 1970s, there's a backlash to the social movements of the 1960s and the early 1970s. And there's a backlash that's basically saying that these hippies, these radicals, right, these activists are destroying our country, and that we need to bring back hardcore Christian values, moral values. We need to return to the moral values of the 1950s, right? In order to basically counteract this liberalization and this progressivism of the 1960s. And so you see the rise of the religious right in the 1970s and into the 1980s, and that continues, even into today. For Christians, and I used to teach a class on religion and politics, that Christians often, up until the 1970s, most Christians, in particular evangelical Christians, they kind of sat on the sidelines when it came to politics, right? They were sort of like, look, our main focus is the afterlife, living a moral Christian life on earth and preparing our souls for the afterlife, for the eternal, life in heaven. And getting involved in politics was seen as sort of dirty business. So a lot of evangelical Christians just sat it out. They were saying, you know what, politics, that's man's world. My eyes are on God's world. I ain't gonna get involved. But when the Christian right, they decide they can't sit on the sidelines anymore. That as they see that these progressive movements are really, advocating for women's rights, advocating for abortion rights, advocating for the rights of gays and lesbians, they said, nope, we can't sit on the sidelines anymore. We've got to reinsert Christian values into our nation. And so you see the development of the moral majority, the rise of Jerry Falwell and Pat Robertson, and Phyllis Schlafly, who you may or may not be familiar with, but she was a woman's rights advocate, but she was advocating for a more conservative vision of what it means to be a woman, to be a mother, to stay at home. And she was activated a lot of people to reject the Equal Rights Amendment, and she did so successfully. And so that's sort of the shifting, social and political landscape during this time period, post Roe and post the social movements of the 1960s. And so in 1980, the Republican Party begins to embrace the Christian right, embracing leaders such as the moral majority and Jerry Falwell, Pat Robertson, etc., Pat Buchanan, because they really feel like their ticket to winning the White House is to align with the Christian right. And gosh darn it, they were correct. President Reagan, elected in 1980, really tapped into this sense of, sort of like returning the United States to its glory days, right? Sounds sort of familiar with Trump, right? Who pursued sort of a similar trajectory in terms of returning us to the past. And so President Reagan, he was the first pro-life president. In fact, when he was governor of California, he was not pro-life. He was pro-choice. But that the Republican Party saw that their political successes were going to be with aligning with the Christian right, and that was a good bet because it did help the Republican Party quite mightily. And so then, we also see the development then of like the pro-life identity. That is that those who are, do not support Roe v. Wade and want to protect the life of the fetus, the unborn child, and the pro-choice movement that is supporting a woman's right to choose to have an abortion. And so the lines are sort of drawn in the sand, and things become much more polarized starting there at this time period, and that polarization continues today. So following Roe v. Wade, we see this identification of pro-life and the development of the pro-life movement in the United States, really as a reaction to Roe. And so the pro-life movement has specific goals responding to Roe, which establishes this constitutional right to have an abortion. One goal that the pro-life movement has is to amend the Constitution. So we know that that when the Supreme Court makes a decision, there are two major ways that that decision can be vacated or changed or overridden. One is if you have a new decision of the Supreme Court, right? So we know that the concept of stare decisis, settled law, but we also know that courts can look back at previous cases and say that that case was wrongly decided, and then they can vacate that decision, right? Now, that's not likely to happen right after 1973, right? Some time is going to pass, right? And it's maybe likely that Roe will be overturned in 2022, and that's been quite a period of time that we've had that the Roe has stood, that decision has stood. So initially, the goal wasn't to overturn Roe, but it was to amend the Constitution. So one way you can overrule a court decision is with a new court decision. Another way that you can overturn a court decision is by amending the Constitution, actually amending the Constitution in order to protect the life of the fetus, prohibiting abortion, whatever that amendment would be. There was not a lot of support for amending the Constitution to include a pro-life amendment. And it's also enormously difficult to amend the Constitution. And so while that was initially a goal, the secondary goal was to ultimately overturn Roe, and that it may take a while to do that, but the long-term goals of the pro-life movement is to overturn Roe. And so in the meantime, like I said, a decision isn't going to be overturned so quickly, usually. So in the meantime, what the goals of the pro-life movement was to change abortion laws, not to get rid of Roe, but make abortion laws much more restrictive and and have states place a lot more regulations on abortion, making it more difficult for women to exercise their constitutional right to an abortion. And that's basically the background of the Planned Parenthood v. Casey case, because that case is about the state of Pennsylvania that puts into place a lot of regulations on abortion. And the question that comes to the court is, are these regulations constitutional? So let's turn our sights to Casey. So the Planned Parenthood v. Casey case is about a series of laws that the state of Pennsylvania enacted in 1982. And so the state of Pennsylvania amended its abortion laws with a new set of laws called the Abortion Control Act. And that the goal of these new laws was to require women seeking abortions to do certain things. And so in Pennsylvania, women seeking an abortion must sign a consent form. that they had to wait 24 hours. So they would have to meet with a doctor at the abortion clinic, and then they would have to wait 24 hours and then come back and get the abortion. And the thinking behind that is that, women, I guess would, be thinking about having an abortion on the spur of the moment. And so they need some time to think about the gravity of their decision. That doctors must provide list of adoption agencies to those seeking abortions. For minors under the age of 18, they must get parental consent, that there must be spousal notification prior to an abortion. And so if a married person is going to be getting an abortion, they have to get assigned consent from their spouse prior to getting that abortion. And then also clinics they needed to keep comprehensive records of those seeking abortions. And so basically, women seeking abortions had to fill out long questionnaires about their age, about their sexual practices, about how many pregnancies they've had, have they had other abortions, etc. And so all of this regulation in place, you could still get an abortion, but that you had to be subjected to these regulations as a part of these changes to the Pennsylvania law. So what were the two sides in the Casey case disagreeing about? What was the dispute that was coming to the court? Well, Planned Parenthood obviously opposed the Abortion Control Act laws of Pennsylvania. They basically said that women have a constitutional right to an abortion, that this right is a fundamental right, and that strict scrutiny must be applied to those regulations. And they basically said that there's no compelling state interest for these regulations that Pennsylvania put into place, basically, violating the ruling in Roe v. Wade. The state of Pennsylvania takes a different approach to these laws, and obviously, since they're Pennsylvania laws, they defend these laws. They basically take a two-pronged approach. Now, you want to keep in mind that, as I mentioned on an earlier slide, that the goal of the pro-life movement is ultimately to overturn Roe. But in the meantime, they were passing regulations, making it more burdensome for women to get abortions. Their plan was that if they passed these kinds of laws, putting regulations on abortion, that where there wasn't a clear, compelling interest for these regulations, that the Supreme Court would have to hear the case, and in doing so, they might actually overturn Roe. And so there was a lot of hope for the pro-life movement that when Casey was being heard by the Supreme Court, that this was going to be a moment where Roe was actually going to be overturned. So the state of Pennsylvania takes sort of two approaches to this. On the one hand, they say that that Roe should be upheld, but that the right to have an abortion should be reduced in terms of its status, and that the right to abortion is a right, but that it's not a fundamental right, and therefore it's subject to reasonable regulations. Compelling interest is not needed, and that these regulations from the Pennsylvania law are in fact reasonable. They took another approach too, saying, okay, well, what the court can also do is they can overturn Roe altogether and return the decision making to the legislative process. To take away the constitutional status of the right to have abortion and let states decide for themselves whether or not a woman should have the right to an abortion, and to what degree to what extent women can have an abortion. And so those were sort of the two approaches that Pennsylvania took. So what is the question before the court in Casey? The question is, does the Pennsylvania Abortion Control Act violate the constitutional right to privacy? And in a 5-4 decision, and you'll read about it in the textbook, it's a pretty bitter, hot, quite of a divided court on this issue. That the courts judge in favor of Planned Parenthood, upholding some of the provisions of the Pennsylvania law and striking down others. But it's a little bit more complicated than that. So let's dig in to take a look at the reasoning of the court and really what they ruled in the Casey case. So probably one of the most important aspects of the ruling of Casey is that the central right to an abortion is affirmed. So Roe v. Wade is not overturned by Casey. It basically says that states cannot prohibit women from choosing an abortion prior to viability. So in a way, it's a loss for the pro-life movement because Roe v. Wade is not overturned. However, there is a change in the standard used to accommodate the interests of the state. In Casey, the trimester framework that we talked about in the last lecture is thrown out. The trimester framework is no longer used by the court. Furthermore, strict scrutiny is no longer used to evaluate regulations, okay? Instead, the court creates what's known as the undue burden test. And basically that when regulations are put in place, that the state doesn't need to demonstrate a compelling interest, but rather the law is invalid if it places a substantial obstacle in the path of a woman seeking an abortion before viability. So if a regulation creates a substantial obstacle before getting creates a substantial obstacle for women seeking an abortion prior to viability, then that law would be deemed unconstitutional. However, if it doesn't place a substantial obstacle in the path of a woman seeking an abortion, then that regulation would be considered constitutional. So what the court says is that states may take measures to ensure choice is informed, the choice to have an abortion is informed, and they can persuade women to choose life options, as they did in Pennsylvania, giving people information about adoption rather than abortion, as long as these measures do not pose an undue burden, a substantial obstacle in the path of seeking an abortion. After viability, holding with Roe, the state can regulate and forbid abortion except when the life and health of a woman is at stake. So it's kind of a mixed ruling. On the one hand, Roe is reaffirmed. However, that they allow for the states to have regulations on abortions that prior to viability, and that those regulations just cannot present a substantial obstacle in the path of a woman. So what about the specific provisions of the Pennsylvania Abortion Control Act? Were those provisions deemed constitutional? Which ones were not? So the signed informed consent form and the waiting 24 hours to get an abortion was seen as not presenting an undue burden, therefore it was constitutional. Parental consent for minors, constitutional, didn't present an undue burden. Clinics can keep comprehensive records of those seeking abortions, not a substantial obstacle, constitutional. However, the spousal notification prior to an abortion was found to be unconstitutional because the thinking was that having to get approval from your spouse, particularly if you were in a relationship that was not healthy, that wasn't, had domestic violence in it, that really would place a substantial obstacle in the path of a woman seeking an abortion prior to viability. So that was the only provision of the Abortion Control Act that was deemed unconstitutional. So what are we to make of the ruling in Casey? Well, obviously the court does not overturn Roe v. Wade. It reaffirms the central holding of Roe that a woman should have the right to terminate a pregnancy prior to viability, that is prior to 24 weeks. However, the court in Casey substantially changes the approach to evaluating the constitutionality of restrictions. The compelling interest analysis is dead, and so now states can enact regulatory laws at any point in the pregnancy in an effort to promote life and motherhood as long as it does not place a substantial obstacle to the right to get an abortion. Okay, so the ruling in Casey has some pretty, strong implications. You still have the right to have an abortion. However, the state can pile on regulations even prior to viability, can put regulations in place in order to potentially make it more difficult for women to get abortions. All right, so this brings us to the Roberts Court and the big question about whether or not Roe v. Wade will be overturned during his tenure as Chief Justice. So, Chief Justice Roberts has been the Chief Justice since 2006. That's when the Roberts Court began. And for most of the time since he's been Chief Justice, the majority of the court has supported Roe. And so when you look at Justices Kennedy, Ginsburg, Breyer, Kagan, and Sotomayor, all of them have voted to affirm Roe. Keep in mind that Anthony Kennedy was on the bench and ruled in favor of Roe in Casey, the case that we just discussed. But as we also know that Kennedy has recently retired and been replaced by Justice Kavanaugh. And so the number of votes on the Supreme Court that is willing to overturn Roe has changed significantly. And so when Justice Kennedy was replaced with Brett Kavanaugh, and Justice Ginsburg, who died in 2020, was replaced with Amy Coney Barrett, it looks like the court now has enough votes to overturn Roe. And so Justice Thomas, Justice Alito, Justice Gorsuch, Justice Barrett, and most likely Justice Kavanaugh too, would all vote in favor of overturning Roe, or at least expansive, or at least significantly reducing the rights under Roe. With Roberts, that it's possible that we're not sure how he would vote. But they don't really, those justices that want to overturn Roe, they don't need Roberts, because Thomas, Alito, Gorsuch, Kavanaugh, and Barrett make up 5 votes. Robert, Breyer, Kagan, and Sotomayor are the 4 votes. Breyer, Kagan, and Sotomayor pro-Roe. Roberts, maybe a middle ground, but in some recent cases, he has actually found some restrictions on abortion to be unconstitutional. So right now, the court is sort of set up with votes that they probably have the votes in order to overturn Roe. So the Supreme Court probably has the votes to overturn Roe. The question is will they do that? Well, we'll get the answer to that question in a case that is going to be decided by the Supreme Court at the end of this court session, probably in June or July of 2022. The case is Dobbs v. Jackson's Women's Health Organization, and this is a case that has to do with a Mississippi law. So in 2018, Mississippi passed a law which prohibits all abortions with few exceptions after 15 weeks. Okay, so well prior to viability. The Women's Health Organization in Mississippi, the only abortion clinic in Mississippi, sued the state of Mississippi, saying that this law was unconstitutional. And this law has been on hold since 2018. And it's been on the docket of the Supreme Court for a while as well. But the Supreme Court didn't take it up until after the death of Justice Ginsburg, suggesting that they now potentially have the votes. And so, we'll find out whether or not this law is unconstitutional. And there's a couple of things that could happen. It's possible that if the court finds that this law is in fact constitutional, that the viability standard for Roe is gutted. Basically, Roe says that states can't prohibit abortions prior to viability. This law prohibits abortions prior to viability. So if the court finds this law to be constitutional, that provision of Roe is gutted. The viability standard is gutted, basically making Roe sort of like an empty law. So they may not or an empty decision. They may not come out and overrule Roe, but they might say that laws prior to viability are in fact constitutional. So how might they do that? Well, it's possible that the court will rule that Roe stands, but that prohibiting abortion after 15 weeks does not pose a substantial obstacle to getting an abortion. They could say, you know what, you still have a right to an abortion. You just need to get your abortion prior to 15 weeks. And that's enough time for a woman to get an abortion. Therefore, this law does not pose a substantial obstacle. So that could happen. But really, we don't know what's going to happen. Listening to oral arguments, most people think that the court will find the Mississippi law to be unconstitutional. But a lot of times people think something's going to happen based on oral arguments, and it does not happen. So all we can do is stay tuned, because we'll find out the answer to this question in a few months. So that's it for me. Thanks a lot for paying attention, and I'll talk to you again soon.